Nice to be back. Thanks for having us again.
Yeah, you look very pretty on screen.
Oh,
Real
thank
person
you.
also.
I think it's Steve Jobs that's looking good.
You. Uh, so today's webinar we have here Miss Geeta, Director of Trademarks and Designs Division at CAS International. So the topic is confidential information and trade secrets. What your employees can live with and what they can't. So this is very important because all the information is being processed by certain employees, and you want to keep that information in the company even if your employee leaves. Okay, so the webinar will start. The webinar start now until 11:30. It includes the main presentation and also Q&A. So in this webinar, you will learn what confidential information and trade secrets really are and what they are not, how to maintain confidential information and trade secrets, what to do if they are misused, how to manage confidential information and trade secrets, and how to make sure your employee do not become your future competitor. So let's put our hands together to welcome Miss Geeta. Thank you.
All right, thanks, Ivana. Hi again, everyone. So a bit about me, if you have not met me before. I'm Geeta from CAS, and I'm an intellectual property lawyer with 13 years of experience. So at CAS, we advise on anything to do with intellectual property, be it the technology you've created, the designs that you've created, or a database of clients. How do you protect a database of clients? The brands that you have. If you want to franchise the brands, we advise on franchising. So pretty much anything the intellectual mind creates, we come in and we advise you on can you even protect it? Or if you can't, then what can you do best? So that brings us to confidential information. Confidential information and trade secrets are intellectual property. It's creation of the mind. So it's information that you've gathered over the years. So this information is actually really important. So what employees can live with and what they can't becomes a knowledge that is very vital for all business owners or employers to know. And employees as well, because as employees, they'll know what they can actually take lawfully and what they can't take lawfully. So please be very interactive. Pop in your questions in the chat box or wait for Q&A. Either way, I'll address all the questions and make them as relevant to your own business so that you get as much as possible out of this webinar today. So to begin with, we're talking about what if your employees suddenly go missing, they resign or walk away? What are they leaving with? This could be physical items, documents. What are they leaving with? Does it belong to them? And what's in their brain? The memories that they have with what they did, marketing strategies, client names, client numbers, figures, all your financial figures if they were in the management team. What belongs to them? We will be exploring that. And who is an employer and who is an employee? So this is very important to also distinguish. An employee is different from an independent contractor, meaning an employee is on your payroll. You are paying them EPF, SOCSO, and all the required statutory payments that are required under the law. And an independent contractor is different in the sense that you are engaging them on a temporary basis for a contract. You engage them to deliver services and for a certain period of time, and you pay them a certain amount of money. So that's a contractual relationship. They are not employees. So it's different, and the difference is important because that affects the intellectual property rights. Why? How does it affect the intellectual property rights? Well, if the person is an employee, then the intellectual property that's created by the employee belongs to the employer on the condition that that invention was created during the course and scope of the employee's employment. Meaning it was the employee's job scope or task to actually invent something, or it was in their role, their position and their role to constantly improve either manufacturing or services, whatever their job is, they're constantly meant to improve. So out of that role, they invented something. If that's the case, then the invention goes back to the employer. So the intellectual property in the invention resides to the employer. And this is stated in the Patents Act. So it's a statutory requirement. This is the case in not just Malaysia, in most countries. In some countries, the employees that invented the invention or assisted in the inventing the invention, the technology, may also be compensated. Japan, for instance, has statutory requirements for the employer to compensate the employee for such inventions. There are cases or situations where the person is an employee, but the intellectual property right does not belong to the employer. And this is the case if its invention was created outside the job scope. So they were not employed for that reason, and it was completely different from what they're doing. Okay, I'll give you a very good example. There are a lot of employees who are itching to start their own business. So for instance, let's say they work in a law firm and they're a lawyer and they've got many years of experience, but they're itching to open a restaurant. And in their free time, in the weekends or after work, they coin a name, they come up with a concept, a business concept. Maybe they might even come up with new recipes for the food in the restaurant. So that they are creating. But what they create, there are intellectual property assets there. Recipes, for instance, there's trade secrets in recipes and the brands that they created. The business concept, the layout of the restaurant can be protected. So there's intellectual property rights in all of these ideas they have. And if they reduce to substance, they start actually drawing it out. There's intellectual property rights there. But in terms of law firm or the partnership, the law firms are usually made out of partnership. So do the partners own these intellectual property rights, or would it be the employee? So, and this example goes to across all board. If they're creating something that's not in their job scope, they actually own the rights to the intellectual property. All right, so as for independent contractors, the independent contractors are not employees. So what they have created does not transfer to the employer automatically. So in independent contractors, rule of thumb is they own the intellectual property right. And there's only one act, actually, the Copyright Act, that says in the act, the statutory requirement that says that if you have commissioned work, the intellectual property rights transfers to the person who commissioned the work. So the person that pays for the work owns the rights if they've paid someone else to do it. But the Trademark Act and the Patents Act are silent. Patents are actually really important in the sense that the fact that it's silent is dangerous, which means if you don't actually put it in agreement that you've commissioned someone, he's created this for you, but the intellectual property right in what he's created for you transfers to you. The rights transfer to you. So as an independent contractor, it's very important to make sure in the agreement that you have with your independent contractor that you have rights transferred back to yourself. So this is if websites are copyright. So a website will not automatically transfer to the Copyright Act, but if there's any inventions, okay, let's say you've got software development, or you have hardware, you're creating a hardware, anything that you've asked someone else to create, it doesn't automatically transfer. So you have to make sure your agreements have that agreements have that as a clause that the rights are transferred to the person who's commissioned it. All right, so why is it important? So you have to distinguish independent contractor and employees for the reason of the confidential information and trade secrets that we're talking about today. So basically, anything that an employee creates in their job scope goes back to the employer. So the risk that we have now is that, yes, it goes back to the employer, but it's still within the employee's knowledge. It's still within their skills. They still have a skill set that does what they do because they've been working for many years for the company. So we didn't talk about this. And another thing that I will bring along is I have some cases. We touch on employees using confidential information. Is that lawful or unlawful? We also touch on contract manufacturing. And these are really interesting cases. Contract manufacturing, the cases that we have, if you outsource your manufacturing and the specifications being sent to your manufacturer, can they misuse that? And if they misuse that, can you take an action against them? So those are interesting cases that we have before us. So now what this slide before you shows is that marking a file confidential does not mean the information inside the file is confidential. So in all the documents, just saying it's confidential is not good enough. You have to treat it as confidential. So the document is confidential, it's marked confidential, but it's left on the open or in a common area for a lot of people to access to. And there's no barriers to enter that room, there's no restriction at all. Then the information is not confidential, regardless of the fact that it's been marked confidential. So do be aware on how you are treating confidential information in your operations, in your business. All right, so the best way to actually learn is through stories and through cases. So we have a lot of that for you today, and I hope that you get as much of nuggets of information. And please write down as much questions so that we can go on a case-by-case basis after this. So the first case that we have today is that the judge decided that a party relying on the confidential information must establish the exact nature and extent of the confidential information. So earlier, right before this slide, I was saying that you have to marking your information confidential is just enough. You have to treat it as confidential. So this takes it one step further. This is, you can't treat everything as confidential. It has to be an exact nature and extent. So you must be very clear in your whole bundle of documents or whole information stack. What is confidential and what is common knowledge to all? Okay, in this case, it's a very famous case, Ocular Sciences against Pigeon Care. It's a well-known case that was heard in the UK. Justice Laddie, who's very known in the intellectual property field, decided this case in 1996. So it's a complex case where the plaintiff sued 8 defendants for breach of confidence, infringement of copyright, and design. So the plaintiff here is a manufacturer. They manufactured contact lenses for one of the defendants, AVCL, using a patent license owned by a shareholder and a director in a defendant company. So sometimes the patent is put under an individual name and the individual then licenses the patent to the company. So here, he's the individual who owns the patent rights and he's licensed it to the defendant company, which is AVCL. Okay, so what does this mean? This means that the defendants own the technology, right? They've got the patent license. So why is the plaintiff then taking action? So it's quite interesting in that case, right? If that person, the defendant owns the technology, why is the plaintiff, what is the plaintiff claiming about? So in the purchase and supply agreement between both parties, there was a term that stated that the plaintiff was the sole and exclusive owner of the confidential and proprietary information, but the phrase was not defined in the agreement. So what's good about this is they had an agreement. So for the contract manufacturing, purchase and supply, here they call it purchase and supply, they actually had an agreement. That's very good. Then they actually said that the plaintiff is a confidential, the owner of the confidential and proprietary information. So they went one step further, saying, okay, we are the owners. But the agreement lacked in the part that that information was not defined, that term was not defined. And in the agreement, there's a minimum purchase order requirement. And later on, the relationship between the parties deteriorated, and AVCL, which is the patent owner or the patent licensee, decided to set up its own manufacturing facility. What happened here is the defendant, used the plaintiff's drawing on microfilm for the purpose of designing and ordering some of the equipment. So there were information that they used from the plaintiff's side to set up their manufacturing arm. Was still significant number of plaintiff's senior employees left and joined AVCL. And the plaintiff ceased supplying lenses. Well, obviously, if you've already screwed them over, you will cease supplying lenses. And the plaintiff sued. So they alleged that the following information was copied by the defendant: the design of the equipment and lenses, the processes and materials used, and the software which was written up to help management of plaintiff's business. And in addition to that is the lens design booklet, which was a compilation of detailed dimensions of the range of the plaintiff's lenses and the lens design program. All right, so the plaintiff's definition of confidential information. So in court, see the fact that they say the definition is here, because in court you can't simply go and sue someone and say that they've stole my confidential information. The court will definitely ask, okay, what is this information that you are claiming to be confidential? So they claim that the confidential information included a lot of things, including instructions on how to operate third-party standard equipment, trivial instructions related to personal health and cleanliness, and a bunch of other information. So the court actually looked into that as well. The fact that you're claiming everything is confidential. So the English courts then decided that the plaintiff's claim on the lens design and dimensions failed. The reason for this is this information is public knowledge. Tens of thousands of lenses have been placed on the market over the years, and there's been no attempt to justify confidentiality in relation to most of the dimensions. Meaning, the plaintiff claims the lens designs and dimensions were confidential, but it didn't have evidence to show that this information is only privy to some people. The defendant had evidence to show that this information has actually been in the market over the years. Then you have the plaintiff's lens design booklet. So the court will then assess what's in this booklet. They found that it comprised of a list of individual design features of individual lenses. But this is also readily available. So it was not something that was selected carefully and created just by the plaintiff. They found that it was a non-selective list of publicly available information. So of course, if it's publicly available information, you can't treat it as confidential, even though putting them together requires some time and effort. So what this means is, if you've compiled this publicly available information in an organized manner, that still doesn't mean that it's confidential. And the court also held that the plaintiff's claim for confidentiality in the design of the tooling for the equipment were too wide. So recklessly wide. Again, similar to the information, they claimed everything under their information was confidential. Here's the design, or what they claim as confidential of the design were also too wide, as the detailed dimensions were confidential and not in the public domain. But as the detailed dimensions were confidential and not in the public domain, the copying of the drawings with the dimensions was a breach of confidence. So a large chunk of it was disregarded, but the detailed dimensions were found to be confidential. So that aspect of the information that the plaintiff claim is theirs, they claim it's theirs and they claim it's confidential, the court held it to be confidential. Can you see? It is because it was not in the public domain. So then the other thing that the court held, the other point that the court held, is that plaintiff's detailed designs for the mold and metal parts used for making the molds were confidential. And use of that information was a breach of confidence. Here, the use of derivative work that was created from confidential information is acceptable if the derivative work does not directly disclose or incorporate the confidential information. So if you use the confidential information, but you come up with a third-party work, so here they use the confidential information and come up with their own manufacturing arm. And from the manufacturing arm, if it doesn't disclose any other information that they have in the new manufacturing facility, does not disclose or incorporate the confidential information, then it's fine. So here what it means is you used the knowledge, but you haven't incorporated the confidential information. So you haven't incorporated the drawings, you haven't incorporated the dimensions, the fine details that are confidential, that the other party owns, then it is fine. Which again means you have to be very careful. You have to be very selective of what information you're using and how you're using the information. And the court also held that where at the date of judgment the information is no longer confidential, but it was at the time the equipment was made, because the new manufacturing arm was up, the continuing activity of AVCL did not constitute breach of confidence. So it means that by the time of the date of judgment, this information is already leaked out. So the other party has already taken the information, they've already made use of the information. And it's not just them, it's all their employees, and the information is already out there. So the action and the remedy, the relief that they seek, which is an injunction to stop the other party from continuing with the manufacturing facilities, is not the remedy that's suitable, because the information is already out in the public. So instead, the judge imposed a financial penalty. So this point is actually really important. We have a lot of clients asking us, should I file a patent or should I keep the information as trade secret? So trade secret here is information that you can actually keep as a secret, like confidential information, but you must treat it as confidential. You must treat it as different from other information in your company. But if whatever that is, whatever that you've created, if it can qualify for a patent, which means if there's technology involved, if it can qualify for a patent, it's very important to rely on patent rights as opposed to trade secrets, because number one, if you protect it as trade secret and someone reverse engineers your products and continues to manufacture it from the act of learning your product because they reverse engineered it, that means you can't stop them because you treated yours as trade secrets and you have no protection under the law. If there's no breach of confidence, that means they didn't steal information. They just found out of the information in public. When you, like you say, there's another manufacturing arm, there's a few other companies, the information is out there in the public, all the products out there, the technology is out there, and you can reverse engineer. Someone has done that, you can't sue them because there's no breach of confidence. They haven't stolen the information from you. So the fact that someone can reverse engineer technology is very risky, and that's why patent protection is important in those kind of circumstances. In circumstances where it's not technology and you can't have it protected by patent, then relying on confidential information or trade secrets is of no choice. I mean, you have no choice but to rely on that rights. But it's a risky right, because here, like exactly what the judge decided here, they didn't stop the other party from continuing in their manufacturing arm. And that's actually detrimental to the plaintiff. If someone else has taken information and then continued a manufacturing arm and started the business, they lose out. Now they lost out from ABCL using them for manufacturing. But when the information is already in the public place, public domain, all the courts won't put an injunction because the information is already leaked out. So what happens in most cases, it is an imposition of a financial penalty, a fine, because an injunction is pointless. If the information is in the public domain, another manufacturing company can still start a business. They can't go and injunct all the companies because there's no breach of confidence in the other companies. I hope you understand that. That can be a bit complex, so if you have questions, please feel free to ask me later, yeah? The court here also decided that it's essential that the plaintiff gives full and proper particulars of all information, all confidential information relied on, because the plaintiff is usually seeking an injunction, and unless the confidential information is properly identified, the injunction will be uncertain in scope and would be difficult to enforce. So what this means is that injunctions are actually really dangerous, because if it's wrongly given by the court, someone's business would suffer. So if they are seeking for something as important as an injunction or as risky as injunction, then the confidential information must be clearly identified for the court to even assess, was this misused? And absence of proper particulars could compromise a defendant's ability to defend himself. Of course, if you're saying everything under the sun is confidential, how is the defendant going to defend themselves? Or if you say something that is vague is confidential, again, how will the defendant defend themselves? How will you even say that, no, I didn't copy it, when you've got such a vague term on what is confidential? So being very specific is very important when you're saying what is it that's confidential. Do take note of this, especially if you're business owners, because this means when you put confidentiality clauses in agreements, in your confidentiality clause, what is confidential, what is the information that's confidential must be defined clearly. So the court also held that it is an abuse of process to give particulars of information which was not confidential, because a claim based in part on a wide and unsupportable claim of confidentiality could be used as an instrument of oppression or harassment. So if you're claiming something is confidential, a pool of information is confidential, and you have mixed with some confidential information and some not confidential information, the court will find that the whole claim fails because you're trying to harass or oppress the other party. So the law here, the judgment is actually a really good judgment, and that's why this case was a landmark case. And the reason is that the judge identified a bunch of requirements that are needed for any claim on breach of confidence to be successful. And a competitor or ex-employee is entitled to copy non-confidential material. So the judge even said this, that yeah, they're entitled to copy non-confidential material. Now all business owners are probably grunting at this final ground that the judge gave. But it's true. They're allowed to copy non-confidential material, but take it with a pinch of salt because you also have copyright infringement. So if they copy material and they've taken word slides and booklets, design booklets and operation manuals, and they are using it in their business, then you can sue them for copyright infringement. So there might be other intellectual property rights. It might be not confidential, but they're using the same words and they're using the same flow of presentation, then you might have an act for copyright infringement. But yeah, so this case was interesting. So what happened here? Did they win or did they not? So Ocular Sciences succeeded. You can see some of it. They succeeded in the dimensions of the drawings. That was confidential. But as you saw here, they couldn't injunct the other party, which is what all plaintiffs would want. Everyone who finds their rights misused, you want to stop the other person from misusing it. But it couldn't because it was found that the information is already public, so it was an imposition of a fine. There was a financial penalty to the defendants. Okay, let's move on to the second case. This case is also a manufacturing case, so we haven't gone to the employees, the cases related to the employees yet. In this case, the judge decided that information must be confidential in nature. So it sounds similar to the previous one. Let's explore the case. Here is a case of Kuku against Clark, and it's also a UK case. Most of you already know that Malaysia follows the British law, common law, and so we in court rely on cases that if it's in an area that doesn't have enough supporting cases in Malaysia, then we rely on cases heard in the UK in the arguments in court because they are found to be persuasive. So in this case, in Kuku Clark case, Justice Megari decided this case. And here, the facts of the case is that the plaintiff designed a moped engine and sought the assistance of the defendants in its manufacture, which means they went to a manufacturing company to manufacture what they have designed. The plaintiff supplied the information, drawings, and other aids, such as the list of possible suppliers for the parts of the machine to the defendant. And the plaintiff brought the prototype to the defendant, and the parties discussed over the next 3 months. So the information was basically shared between both parties. A lot came from the plaintiff, and here the plaintiff disclosed the information, right? They were the one who was disclosing a lot of the information. They were the one who designed the moped engine as well, and they gave all the specifications to the manufacturer. But as it does with some business relationships, here as well, the parties fell out. Similar to the Ocular case, so information was shared and then the parties fell out. So, and the defendants here decided to manufacture their own engine. So the difference here is the manufacturer, in the previous case, Ocular was a manufacturer. There, the person supplying the information went off and started their own manufacturing arm. So in this case, the plaintiff is the designer and defendant is the manufacturer. Here, the defendant went and started manufacturing their own engine. That means they manufactured a moped engine. And so whether it's similar or not, so the plaintiff claimed whatever they manufactured is very similar to what they have, their moped engine. It's called a scamp moped. So they felt the scamp moped that the defendants created is very similar to theirs. And they sued on the basis that this was created based on information given to them. So all this while, for the past 3 months, things were going back and forth, and it was definitely from the information given to them. So in this case, there was no formal manufacturing contract. So earlier in the previous case, there was a contract, but they didn't define what's confidential information. Here, you don't even have a contract. So Justice Megari, in this case, set out 3 elements. And that's why this is also a very famous case. She categorized as 3 elements in a breach of confidence case for a successful breach of confidence case. So the 3 elements is that information must be given in a confidential nature. The information, when it's given, the party giving the information must have communicated that it is confidential. That means there is circumstances importing an obligation of confidence. So it doesn't naturally exist. You must be indicating that this is confidential. So first, the information must be confidential. Second is the person delivering the information must indicate that this is confidential. Then there must have been unauthorized use of this information. So it's a very interesting case. So let's see. Were these three elements satisfied? So the court felt here is that of the three elements, only one was satisfied, which is the information was communicated in the circumstances importing an obligation of confidence. So that means information was given by the designer of the moped engine to the manufacturer. And the information, when they gave it, they said that there's a duty of confidence there. That's the only requirement that was satisfied. The judge found that the other two were not met. Okay, let's see, what are the other two? The one is that the information was confidential in nature, and the other one was that there was unauthorized use of the information. They felt that these two were not met. Okay, back to the case here. The facts of the case was also that the parties had common experience and common knowledge in these types of machines, and they knew a lot of the information because they were both parties that are knowledgeable in this field. So they both are skilled in the art. They both know the technology here. And this information was shown through correspondences that took place between them. Okay, what this also is very important in cases in court is that everything is based on evidence. So it's very difficult to claim something if you don't have evidence to support it. So here there's correspondences to show that the manufacturer was also knowledgeable in this field, not just the moped designer. So not just the plaintiff who took the action. See, the plaintiff designed the moped and sought the assistance of the defendant. So they could show that the defendant also knew quite a lot of information. And the facts are against inferring a confidence between the parties. So this means that the facts that Kate was brought forth and what the defendant argued is that all these engine components, because the defendant went on to manufacture their own moped engine, right? So the defendant could show that the engine components can be purchased on the open market in the same way the plaintiff's design can be purchased in the market. So meaning the plaintiff's design wasn't unique to begin with. All the products used in the manufacturing is not unique. Everything's available in the public. And plaintiff's expert evidence was not convincing. So they found that from the expert evidence, which they could poke a lot of holes, they found that the ideas and similarities between the design and the components between both parties' mopeds were common to the moped world. So if the facts of the case show that actually this is common information, what is the plaintiff claiming? So here they found that the information was not confidential in nature. So that's why the court held the first point. Yes, there was obligation of confidence. So there's evidence to show that when it was released, the other party said, treat this as confidential. It is confidential. But the first one, which is the information was confidential, was failed. That means the information that was given was not confidential. It's common information in the marketplace. Okay, the court also went to a hold that the evidence adduced by the plaintiff failed to reveal that the similarities between the defendant's engine and its own engine were achieved using the confidential information. So it means that there was no utilization of confidential information for the defendant to come up with his own engine. So that was the decision in this case. So in this case, the manufacturer succeeded. The person that came to the manufacturer and there's 3 months discussion failed. That brings us to the case of employees. So I hope you learned from the manufacturing case, and if you are a manufacturer or you yourself do manufacturing and you outsource your manufacturing, be very careful in terms of the agreements. The previous 2 cases shows that it's actually really important to identify what's confidential and make sure you have an agreement, and in the agreement is also identified. Right, now moving on to the cases on employees. The case that we have before us shows that employees cannot be prevented from using their own general skills and knowledge. Now, what does that even mean? What is own general skills and knowledge? That sounds extremely subjective. Of course, employees will say that everything is within their general skills and knowledge, and employers will claim that everything is their own, everything is their confidential information. So it sounds like there will be a definite argument there between both parties. So that I would like you to take this uh, provision in the Contracts Act also in light in this every discussion about employees, because you'll find a lot of contracts have a restraining clause. They say that, especially in franchise contracts, you restrain another person, a franchisee, from starting the same business for a certain period of time after the franchise agreement ends. So, and among other contracts as well, it's called a restraining clause. So the Contracts Act provides that any agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. So the reasoning behind this is that, and the reasoning behind this, that employees cannot be prevented from using their own general skills. So here is common law. There are cases to show that you cannot be prevented from prevent employees from using their own general skills and knowledge. And this, you can't restrain someone from exercising a lawful profession, trade, or business. The reason there's these restrictions is that the rationale behind it is that everyone deserves to earn an income for their own rice bowl. And if that one person has developed skills and knowledge in that specific field, it's only practical that when they leave employment or when they leave a contractual agreement, they enter the same field again. So it's viable. You need to be able to provide for your family. You need to be able to provide for yourself. You need to be able to earn an income. And if all your experience is in that field and the law allows someone to put a stop to that, then it becomes a very dangerous world to live in. Every time you'll be changing profession and you'll be starting back from scratch again. So the law takes care of people's needs. So that comes to I said the law takes care of people's needs. Well, that contradicts the law taking care of the business owner's needs. Because the business owner also spends a lot of time, effort, and money in building their business. So how then? You take care of the employees' needs and the people's needs, but how about the business owner's needs? So it's really it's a balancing act. So that brings us to this case. So when we explore this over the next few cases, you'll see that the business owner's needs are also taken care of. But it really needs to be a balance, and it becomes also quite subjective. All right, in this case, in the Facenda chicken case against Fowler, and I'm going to say the same thing I said earlier, this is also a very famous case. The Facenda chicken case is a British case as well. Okay, so here Fowler is a sales manager, and he was an awesome sales manager. So don't you love it when you have an awesome sales manager? Well, here the plaintiff was involved in the business of breeding, slaughtering, and marketing fresh chickens. And in 1973, the plaintiff employed Fowler as its sales manager. And Fowler was very innovative. He came up with a very profitable and brilliant idea, which was a method of selling fresh chickens from refrigerated vans which travel through particular routes within a defined area. So why is this a brilliant idea? Well, he made traveling salesmen with the chicken themselves. They don't just make sales, they actually make sales and they deliver the chicken as well. And he made the vans refrigerated so that the chickens go to where it needs to go, is delivered where it needs to be delivered, and in a very speedy time because he arranged the routes for all the traveling. So what happened was that this was very good in terms of sales. Sales picked up big time. And each van salesman received sales information regarding the customer's names and addresses and general limits of the routes, the quantity and quality of goods sold, and the prices. So the salespeople basically knew each customer that they're delivering to and the customer's preferences and the prices charged, because different customers will also price different according to their specific pricing schedule. And 7 years later, this amazing salesperson left and started his own business. Sadly, providing the exact same services in the exact same area. So what does Facenda Chicken do? Well, they do what all business owners do: protect your market share. How do you protect your market share? You sue the other person. So they sued Fowler. Fowler also took 5 bank salesmen from the plaintiff, and 3 other employees from the plaintiff joined Fowler after that. So then they have 8 people who left the plaintiff's company, the Sender Chicken, and joined Fowler's new company. Band sales dropped, and when 8 people left, the division itself became less profitable. So in the suit, the grounds of suing was that they stole confidential information, not Fowler stole confidential information. And they said that the names and addresses of the customers were stolen. The most convenient route to be taken to reach the individual customers was stolen. The usual requirements of individual customers were stolen. The days of the week and the times of the day when deliveries are usually made to the customers, and the prices charged to the individual customers. The court, it went to 2 layers of court here. It went to the High Court and then it went to the Court of Appeal. The court held that confidential information that is revealed to employees can be restricted from usage after they leave employment only if the information is treated as trade secret. So here, similar again to the cases I showed you in the manufacturing line, it's very important that it was treated as trade secret. Here, okay, let's see how you treat it as trade secret before we go to the facts of the case. The court also held that to determine whether the information is trade secret, it is necessary to consider the nature of employment. Example being, did the employee regularly handle confidential information and recognized it as such, or was information only handled by a restricted number of employees? And the nature of information, whether the employer had stressed the confidentiality of the information, and whether the relevant information could easily be isolated from other non-confidential information, which was part of the same package of information. So what is confidential comes to a question here again. And here the court also said, can you actually dissect it? Is it isolated from non-confidential information? Did you treat it as confidential? Did you put it upon the employee? Did you stress the obligation of confidentiality? Was also considered. So then the judge, upon applying that test, found that neither sales information as a whole or the information on the prices charged by the plaintiff fell within the classification of trade secrets. Though the information about sales price is of some value to the competitor, it could not be regarded as plainly secret or sensitive. So it's very interesting. And what it shows here is that information that the plaintiff of course found as confidential, but he didn't treat it as confidential. And that could be for various reasons. Could be, for example, they said that was it only handled by some people, or was it freely available to many people? Was it available on a database that many people had access to? So based on the facts of the case, they found that it was not treated as confidential. The sales information was within the knowledge of Fowler and the ex-employees, and the use of the information was merely use of the general skills and knowledge gained from the previous employment. So this was the defense that Fowler and the others said, is that these are information that I've learned over the general skills and knowledge from this previous work. And okay, so this is where it's very, very subjective. So it's information on the routes and information on the pricing. It's arguable that it's not actually general skills and knowledge, but here it's that some would have been confidential if they treated it as confidential. So for the defendant to argue this, it's the main thing is probably it wasn't treated as confidential. So if they had treated the information as confidential, they were more strict about who had access to the information, how much of information was given out, then it could have succeeded in that case. It gets tricky when there's a lot of people in the company and a lot of people need access to the information. And later we'll talk about how can you actually keep confidential information treated as trade secret or treated as confidential. There are ways, including giving information to only specific people. So like all the routes are not given to everyone, given to only specific people. Certain routes, certain people. So you be very careful on a need-to-know basis. You reveal information on a need-to-know basis. So, and you also make sure that they are aware that it's confidential and they sign confidentiality clauses in your employment agreement. So the court here also held that the defendants are not entitled to take a copy of the plaintiff's instructions away with them, but insofar as the instructions cannot be called trade secrets and he carried them in his head, he is entitled to use them for his own benefit or the benefit of any future employer. So this is information that you don't copy, but you have information in your head. And so these are examples of trade practices. So trade practices that when you leave one employment to another employment, and your employer is actually employing you, your new employer is employing you, on the reason that you come with experience. If you come with experience and don't improve the new company, then why do they even bother hiring someone who's experienced? So your skills and knowledge are actually important to the new employer, the future employer. So what's in your head can be used. So you have to be very clear as an employee, you have to be very clear that what you're using are not confidential information, not trade secrets. You were not told that these are very privy information, and only very few people were given access to them, including you. So you have to be, that's why I say it's very, very subjective. What is general skills and knowledge and what isn't general skills and knowledge. So what clearly isn't general skills and knowledge, for example, is all the phone numbers of your clients. There's no way someone can remember all the phone numbers of their clients or the company's clients, because our brain, especially in this day and age with so much of technology, you can't remember numbers. 3, 4, our phone numbers have 10 digits, I think. So imagine having 10 digits of numbers of 20 top clients. That's very difficult. If any of you listening now are thinking of what numbers you remember, chances are very high that you remember the numbers of your family members. And those who probably are older will remember a lot more numbers, because in those days, we actually used to have to ring those numbers and we didn't have the mobile phones storing the numbers in a way that you could store now with a contact database and so on. So it's very subjective. And in court, they will assess, are this information that you copied? Did you take a database out? Or are these just information, trade practices that you know because of years of being in the company? And then the court ended with the specific trade secrets are so confidential that even though it may necessarily be learned by heart, and even though the employee may have left the service, they cannot lawfully be used except for the ex-employer's benefit. So there are cases where you can learn it by heart, but if it's a trade secret, you can't. So that's why I said it's very subjective, and the judge will assess what is this information. That's why the main question you find all these cases, we've talked about 3 cases now. All of these cases you find, all of them are asking, all the judges are asking, what is this information that you are claiming is confidential? So the information has to be specific. What is this specific information? That brings us to the 4th case that we have today. The use of names lingering in your mind due to years of experience is not breach of confidence. So the use of names lingering in your mind due to years of experience is not breach of confidence. So we talked about this earlier as well. I said you can't remember 20, but maybe you can remember 2. Okay, let's see what this case said. In Coral Index Limited versus Regent Index Limited, this case was interesting. It wasn't just confidential information that the other party sued. They also sued for infringement of copyright, and they also sued for passing off the name. They said Coral Index and Regent Index are very similar, and that's why you're passing off your business as if it's my business. So that's the thought of passing off. So in this case, the plaintiff carried on a business of accepting wages concerning movement of the Financial Timeshare Index. That's where the word index comes in the brand. The defendant, the second defendant, K, after being employed for 5 years as the plaintiff's office manager, resigned and assisted with the establishment of a new rival business, the first defendant. So the first defendant, the company, and the second defendant, the person in the company. So there's competing businesses, and this is very common. Basically, ex-employee goes and starts a new company that competes with their previous employer. So K sends literature to several of plaintiff's customers, and the literature was similar to that of the plaintiff. So the plaintiff sued with 3 causes of action. Breach of confidence. The previous employee, they say the previous employee took away a customer list or memorized the list, and the literature was copied. So here is a case of copyright infringement, and the use of a similar company name which would suggest association with the plaintiff. So that's passing off. the court here held that it was difficult to infer that the K walked away with the customer list. So, what happens here is that if there's no evidence that someone stole the customer list, or he suddenly contacted a lot of people, which the court can then infer. Infer means the court assumes that you have copied and you walked away with a database. When you suddenly contact many people, there's no way your brain can store that much of information. So here that the judge said that it's difficult to infer, it's difficult to assume that he walked away with the customer list. So he clearly already says there's no evidence that he stole it, and it's difficult to assume that he walked away with it. K was working there for 5 years, and it was impossible to suppose that he did not get to know a large number of clients well. Even if he had average memory for people's name, he could not fail to carry away a considerable number of names and even addresses without any conscious attempt to make a mental list of them. So it means he walks away with memory, and he will have memory of names and addresses. You have to remember this case, actually, Coral case is also quite an old case. So this is the case of before we have the iPhones and all the Samsungs and Android phones, where it has technology doesn't allow us to remember a lot of things these days because we're so reliant on technology. So our memory sometimes fails us. Why do we need to remember? So we don't actually bother remembering them unless it's your immediate family member. But so here, this is an old case. So this day and age, it's very difficult to argue this, that you can store so much of numbers and names in your head. So the second thing that they held here is literature is similar to that of plaintiffs, and the copyright infringement was established. So here there was a case of copyright infringement because the written material was found to have been copied. Similar means it's not identical, but a substantial part would have been copied. Because for copyright infringement, a substantial part has to be copied for there to even be a case for copyright infringement. And the third finding of the court was that for the passing of action, the only similar word used between the parties was index. And it was related to a trading index, so that word is descriptive of the business done. And because of that, the defendant cannot have been said to mislead the public by using the word index in their brand. And the dominant word in the brand, which is Coral and index, are very different. So there's no case of passing off here. So here in this case, the plaintiff succeeded on the copyright infringement but failed on the other two grounds, which is breach of confidence and the thought of passing off. That brings us to the fifth case, and we've been talking about cases abroad, mostly the cases in the UK before this. So let's look at some local cases. Many people actually ask me, like, are there actually cases, do people bother taking cases in court when people walk away with information? Well, the answer is yes, and you'll see these cases that we have before us. Another frequent question that clients ask us, why bother registering when it's so difficult to stop someone from using it? And this applies to patents, trademarks. So these are all registrable rights. Why bother register when you can't actually take an action against them? So that's also all assumptions, wrong assumptions, because if you actually protect them, and there is a misuse, a clear misuse, or very high likelihood of misuse being found, you can actually succeed in court. And the courts have had cases where intellectual property owners win. So it really depends on how much have they been copied. Was there any actual copying? And it's all based on facts. Okay, in Sun Sing and palm oil mill case, this case is about confidential information as well, and a patent. So in this case, funnily, it's also a case about a husband and wife. And after the divorce, she leaves the husband and starts a competing business. So the plaintiff here initiated an action to prevent the defendants from using confidential information belonging to the plaintiff. So the plaintiff owned Malaysian patent. There's one Malaysian patent and one Malaysian utility innovation. So utility innovation is also protection for technology, but it has lower criteria than a patent. And if you have questions on those two, please drop us an email or put it in the chat box. That garners another training altogether. So we can't talk about different between patent and UI here. But anyway, they had a patent and a UI, and that claimed shredders used in a palm oil mill. So the first defendant, Jang Kim Rong, was the ex-wife of Tai Sui Kian. Tai Sui Kian was a director in Sun Sing Palm Oil. So the Tan Sui Kian's wife, which is Jang Kim Dong, had a lot of experience in the milling and sale of crude palm oil, palm kernel, and recycling of oil biomass from her prior employment. So while she was still married to Tai Sui Kian, she was CEO of Sun Sing Palm Oil Division and had access to various confidential documents during the operation. Well, as CEO, you will have access to a lot of confidential information. You are CEO after all. How do you run a company without the information? So when their marriage ended, the first defendant went on to start another company called Eco Future, which is also brought in as a defendant. And she started it with Fung Lai Sun, so who is also another defendant. So all these defendants were named in the suit as they were indirectly, 4 to 7 defendants were indirectly named. Sorry, they were named in the suit because they directly or indirectly connected to the second and third defendant. Meaning there were other companies and there were other subsidiary companies that were created, and all of these were linked to the Eco Future Berhad, which is a defendant. Upon termination of the contract with the plaintiff, the first defendant started with the fifth defendant and then worked together to develop another shredder, which they argued during the trial that it doesn't infringe the patent and the UI of Sun Sing palm oil mill. So the plaintiff argued that upon the termination of her contract with Sun Sing palm oil, the first defendant had had an obligation not to disclose confidential information which belonged to Sun Sing to third parties, to return all property and confidential information to plaintiff upon termination, and had a fiduciary duty to act in good faith and in the best interest of Sun Sing palm oil division. So there is fiduciary duty means there's a special duty to act in a beneficial manner to your employer. So all employees actually have this duty. It's a duty to act in good faith for your employer. This level of duty is a lot higher for managerial positions because they are managers, and as CEO should have a higher level of duty to act in good faith. During the trial, the defendants alleged that the first defendant is one of the owners of the patent. The first defendant is the wife, and she claims this as she was involved in the development of the shredders, which are the subject matter of these inventions of this patent. And the new shredder was developed without using any confidential information obtained during her course of work with Sun Sing Palm Oil Division. However, the defendants were not able to produce any evidence to support their allegation. So it's very interesting. Okay, earlier, do you remember I was saying about employees? What do employees have and what they create in their job scope goes back to the employer. So here for the defendant to claim that she was one of the creator or the inventor, she's claiming I'm one of the owners and I was involved in the development of the shredder, so I have rights, is wrong because actually that ownership goes to the employer. And if it was in your job scope to create or to improve processes, products, manufacturing line in your job scope, that goes back to the employer. So this actually is a very weak argument. And the defendants were not able to produce any evidence that they were not using confidential information. Basically, like all the previous cases, you need to show that this information wasn't confidential, that it was common knowledge, that this information is available in the public. Okay, let's see what did the court hold. Here the court held that the first defendant was an employee of Sun Sing Palm Oil Division at that time and that she had carried out activities in the performance of a contract of employment which brought about the invention, and therefore there's nothing to the contrary in the contract of employment which suggested that she could claim ownership of the invention. So goes back to what we discussed, the employer owns the invention. So what here it says that nothing to the contrary in the contract of employment means that the law provides that anything that you create in your job scope of employment goes back to the employer, but you can contract out of that rule of thumb. So you can contract out of that requirement if you have negotiated with an employer to have ownership of the inventions that you create. Okay, next is that it is the duty and responsibility of the first defendant to protect and preserve confidentiality during and after employment. She had unlawfully misappropriated the confidential information that she had obtained during her employment with Sun Sing Palm Oil. So here they have evidence. They have evidence that she misappropriated the confidential information, but it's her duty and responsibility to protect and preserve the confidentiality. Because I was saying earlier, there's fiduciary duty, there's a duty, there's higher level of duty of confidentiality for management level staff, and that fiduciary duty here was breached. So in this case, Sun Seng succeeded, and they succeeded to actually put a stop to it because they were using the technology as well, the patent and the UI. That brings us to another local case, Smith Scientific against Ong Han Swan and others. Here, the plaintiff, Smith Scientific, was the employer to the first the four defendants. And so first, the four defendants are all people and ex-employees and dealt in the sale of certain scientific equipment to hospitals, universities, research centers, and so on, for which it was the exclusive distributor in Malaysia. So what happened here is the ex-employees left and they started another company. The ex-employees then approached 3 of the plaintiff's customers, offering the same products that were sold, but for a lower price. And this is common, right? That's how you steal your customers from your ex-employer. You already know your pricing the ex-employer provides. So you just slash the price to get the business. So this is what happened here. One of the customers eventually purchased from the 5th defendant. So the 5th defendant also approached the overseas principal and the supplier of the equipment and tried to get distributorship agreements. So not only they kind of stab them in the back by getting their customers, here they go and try to disrupt the distributorship agreement that the plaintiff already has with their principals and their suppliers. So they approached, and if someone else, the overseas principal here in this case, they agreed to supply, so they made the agreement with the plaintiff non-exclusive and started also trading with the defendant. So plaintiff sued the defendants for breach of duty of fidelity and good faith and breach of confidence. The court held that the duty of good faith and fidelity prohibits an employee from using any confidential information during and post-employment. Where there is a confidential relationship between 2 parties, the court can infer an implied contract. So even if you don't have a contract, it implies a contract, and that duty of confidentiality is implied. Here, the plaintiff had evidence to prove that the 4 defendants had printed out information relating to the plaintiff's customer database, suppliers, and cost prices, and this evidence was not refuted by the defendants. So there's a lot of evidence here. They could show that this information was taken out of the company. And the method of compilation of the list of customers, their specific needs and cost prices were found to be confidential, even if the method of arriving at the selling price of the equipment was neither a unique intellectual work nor ingenious. So it's very interesting here. Can you see how we talked about the Fazenda chicken case? Fowler took similar information. He knew the customers, he knew the routes of the delivery of the chicken, the fresh chicken, he knew the timing, he knew the prices. How come in that case he was allowed to walk away with that information on the basis that that's general skills and knowledge? Whereas here, the court is saying that the method of compilation of the list of customers, their specific needs and cost prices are confidential, even if the method of arriving at all this was neither unique, intellectual work or ingenious. Can you see the difference? The difference here, I find, is that the plaintiff who's bringing the case in court also had evidence that they stole it. See, they had evidence to show that they printed out all this information. And the third one that the court held. Okay, what is in addition to that is similarity of the quotation sent out by the plaintiff to customers and the quotation sent out from the defendant also shows that confidential information was used, especially since the defendant had no evidence to prove otherwise. So here is in the case what happened was they brought in all the documents that the defendant was sending to the customers and the plaintiff was sending to the customers. Everything that that specific customer needed was known to the defendant. They needed specific, because you can see it's a scientific equipment, right? So why is it this specific research lab needed this? Why this specific university needed this? They knew everything that that university needed, to the core, to the design model, to everything that's so specific, which your memory cannot hold. So there's the fact that this information is copied and then your quotation looks exactly or substantially similar to what the quotation that the plaintiff sent previously was. So this evidence was brought as well. They compared the quotation being sent out. And the defendants defended themselves. They claimed that they obtained the product specifications from the market, from the suppliers and customers. But they couldn't support this claim because there's no evidence. So the judge also found that the defendants claimed that it's a restraint of trade. Remember earlier saying that Section 28 of the Contracts Act, you can't stop me from doing something I know. The defendants brought this as a defense. You can't stop me from using my skills and knowledge. You can't stop me from working in the same field. So that failed because the plaintiff said that they do not intend to restrain the defendants from entering the same trade. There are no issues with them entering the same trade. But it's the plaintiff's intention to restrain the use of the confidential information, which is to the detriment of the plaintiff. So this is my information. You're using it to steal my clients, to devote my market share. So yes, I do have an issue against this. So Smith Scientific was successful in this case. Okay, we come to our seventh case, which touches on duty of good faith and fidelity. In this case, in Swenson Hair Care Center against Irene Chin, it's a case where as an ex-employee leaving and starting up another business, which is in competition as well. The plaintiff, Swenson, whose business is in providing skin and beauty care services under the name Bella Beauty Center, employed the defendant. So Swenson Hair Care Center is also a known business, but under the Swenson Hair Care Center, they had other beauty centers. In this center, the name of the center was Bella Beauty Center. They employed the defendant. The defendant was a center manager for the PJ branch of the plaintiff's beauty center. When she resigned, the defendant joined another beauty center and started contacting the previous customers of the plaintiff, asking them to discontinue their treatment contracts with the plaintiff and ask them to try the new beauty center. So they not really left, okay, leaving is fine. Using your general knowledge or your skills and general knowledge is fine. But here they went and asked them to discontinue your previous treatment contracts and come and try this new beauty center. Of course, the plaintiff was cheesed off. The plaintiff felt this is misuse of rights, misuse of information, and they sought an injunction to restrain the defendant from contacting or corresponding with all or any of the present customers of the plaintiff. What was the defendant's defense? She said that she contacted them based on relationships that were developed over time and that she is allowed to leave her previous employment with her skills and knowledge. So this is the defense of all ex-employees. So any cases in court, you will find that this is what they'll say. It's within their skills and knowledge because the law provides it. What? The law provides that it's my rice bowl. So they will rely on that defense. So for business owners to succeed, it goes one step higher. You have to prove that information was taken. You have to prove exactly what they said previously, that the information is confidential, information was given on a duty of obligation of confidence, and it was misused. So in this case, the court held that customer lists and details are clearly confidential, as it was expressly mentioned in one of the clauses in the employment agreement. And the plaintiff's customer names, lists, and details could not become part of the defendant's own skill, knowledge, and business experience, as the defendant had submitted. The reason it's not within the defendant's own knowledge is because there was evidence to show that the defendant had taken possession of the customer's treatment cards during the period of the termination notice. See? So you can see the trend of these cases. If there's evidence that the information was stolen, there's very high chances of succeeding. So in this case, what happened here is during her termination period, she stole a box. In that box, there was customer treatment cards. And a staff saw her stealing this. They saw her taking that box, and later on they found out in that box there was customer treatment cards. So there's a lot of CCTV around these days as well. So this can also possibly be determined from CCTV by monitoring what your ex-employees are doing during their notice period. So Swenson's in this case succeeded because of the evidence that they had. Defendants claim that her livelihood will be affected if injunction is granted was not accepted, as the defendant is an employee in the new beauty center and earns a salary and a commission. So it's not as if Swenson Hair Care is telling Irene Chin not to enter the same trade. They're not restricting her from entering the same trade, but you're restricting her from misusing information that's confidential that belongs to Swenson themselves. Right, and this is our last case for the day before I move on to giving very quick tips on how to protect or how to keep information confidential in your company. So in the last case, the influence of copying is too strong to resist. So here, there's no evidence of copying and the assumption that there was copying. Let's see, why was there an assumption? Why did the court put an assumption that there was copying? In Electrocat in Australia against others, the first and third plaintiffs developed and sold anti-car theft products, which is called stop card auto theft device. The second plaintiff was granted a license to use the trademark stop card in licensed territories, including Malaysia. The defendant was a director and shareholder of the plaintiff and was under a duty of confidence as required by the clause in the license agreement. The defendant then resigned from the second plaintiff and entered into an employment with another defendant, and the other defendant, the fourth defendant, launched a similar product called Stop Car. The plaintiff sued, claiming breach of confidence, breach of fiduciary duties, and passing along. The defendant denied. So their defense was that there is no using of confidential information, and the product was derived from their own technology, and the information was already in the market prior to the Stop Card product. So the court here held that while the plaintiffs took about 2 years to develop the product, the first defendant was able to develop the product in such a short time. So this is where the assumption was that the defendant had copied, because it was put in the marketplace in such a short space of time. So the judge felt that it was too strong to resist this assumption. And he also held that by virtue of his position as a director, Lai owed certain fiduciary duties to the plaintiff, and the duties of a director are those fiduciary duties owed by senior officials of the company and are much higher than that owed by employees and managers. So they must act in good faith of the company, the previous company. The judge also held that the case dealt with trade secrets, which was information which any reasonable employee would recognize as secret to his employer's business. So the defendants were privy to the said information. They were privy to the information. They knew that from this information, you're able to develop a product similar to the plaintiff's product. And the springboard doctrine does not apply here. And as the case was not possible, in this case, it's not possible to reverse engineer the product because of the idea that was in the chip. So in springboard doctrine is that they could reverse engineer the product. So their defense was that I could reverse engineer the product, and that's why I put the product so fast in the marketplace. But that, based on the facts of the case, they found that you can't reverse engineer this product so easily. Right. So that brings us to the end of the cases. You've had information overload today with 8 cases being presented, and I'll later summarize what's important in the cases. But let's move on to how do you then keep data confidential? Because from the cases, you see that it's very important to outline what is confidential. So one is definitely, as a business owner yourself, being very clear what is confidential in your business, in each aspect of your business. So you'll be looking at each department. What is confidential? Then you only allow certain people to access such confidential information on a need-to-know basis. If it's possible, of course, you have to also see, is this viable? If it's going to slow down your business, if clients or customers are going to get whatever products or services you're delivering in a very delayed manner, then of course it's not practical. You have to find different solutions as opposed to revealing information on a need-to-know basis. Also, have employees sign contracts. Make sure that your employment agreements have confidentiality clauses. Or if you have specific projects, have non-disclosure agreements with those kind of projects with either employees or your consultant or vendors, third parties, making sure that they are aware that what is confidential and that confidential information has a duty of obligation to keep it confidential. Also, keep clear record of deals that may cover any confidential information. So sometimes you have discussions in coffee shops, you have discussions elsewhere, and you might be revealing confidential information. Have records. And ideally, whoever you're revealing it to, also make sure they sign a non-disclosure agreement. Now, patents and confidential information. It's very important because there's an overlap here. So it's not possible to maintain a patent and ensure that the information in the patent on the invention is confidential. So for those of you who know about patents, you know this, why we say this. Because when you have a patent, you are revealing everything about an invention, how it works, how do you manufacture the product, what are the optimal process parameters. All of that is disclosed in a patent document. So you can't say that it's confidential when you have a patent document, but you have protection by way of the patent. You have 20 years protected in that technology if you have a patent right. So this is a contradictory, patents and confidential information. Copyright and confidential information. Well, it's possible to still own copyright because copyright exists in every literary work and artistic work, and software that includes software programs because there's programming language there. And also maintain confidential information for the same product. Because source codes, you can limit rights access to the source codes. So you can still enjoy copyright protection because there's literary work in source codes, and you can enjoy copyright protection. You can keep the information confidential as well. So in this overlap, they can coexist. So what else can you do? What can you do to keep information confidential, to protect leakage of information? So these are some tips for you. Before and during the course of employment, you can conduct pre-employment screening, reference checks, call the previous employees, previous employers, ask about them. Because if they have left with information from the previous employer, chances are high they will also not be worthy of your trust in your new employment. Also, train employees and new hires on security awareness, on security policies and procedures, what responsibilities they have in security, keeping security of information, what proper procedures that needs to be done for reporting and dealing with theft and trade secrets in the company. Also, you should restrict access to servers, routers, and other network technology to those whose job responsibilities require access. So you have to then be very careful what access they have, what rights they have. Do they need access to everything in their business, or do they only need access to their specific job scope? So it does take work. It takes work on the business owners to sit down and analyze your business very thoroughly. But it's essential because as you see all these cases of ex-employees starting a competitor firm and then stealing clients or stealing design and dimensions of design and so on, it's very important for you to be careful and take precautionary steps. Also, install surveillance equipment. These are very important when you have manufacturing factories, information on how, because people are being exposed to a lot of processes that might be a trade secret in your business. Keep inventory of the equipment and periodically check for missing equipment. Place locks on computer cases to prevent hardware tampering. Lock files in cabinets and offices that store sensitive information. So these might seem clear to you, but you'll be surprised how many businesses don't actually do this. They don't do an audit of how are they actually keeping the security of information secure. Shred all paper documents containing confidential information before trashing them. Make sure you discard magnetic media properly, which means erasing the information within. If you are renting computers and there's change of computers when the rental period expires, make sure everything is transferred out of the CPUs or erased if you don't plan to keep them. Implement passwords for all employees for access to critical system resources, and make sure the passwords have multiple characters. Change the password regularly as well, and train employees in password selection and train them not to tell their passwords to others. Keep audit logs for all access requests to critical systems and sensitive information. So audit logs will show that who has come to this information, who has changed it, who has amended it, who has depleted it. So this is very important as your company grows. Encrypt sensitive information. If the company's network is on the internet, use a firewall and audit the servers. So a lot of this you can see, you can actually get IT expertise to come in to give you advice, but do highlight that you need all of this. Monitoring the use of computers, emails, voicemail, and internet. And seriously, IT people have a lot of solutions for all of this. Some of the softwares can be considered to be invading of privacy, so you have to be careful of that because you also have the PDPA Act. It's if you are entering, you are monitoring everything they do, your employees do on the computer. You also have to inform them that you're doing that, and so that they don't do personal transactions on the computer belonging to the company, because then you are then monitoring your personal acts. So that can be a breach of the PDPA Act. What else can be done? To require all visitors to wear visitor tags and be escorted at all times. Be careful about visitors entering parts of your company, parts of your factory that could have confidential information. Again, do on a need to know basis. Do they really need access to every part of your factory? Utilize contract and licensing agreements that expressly state the parameters for using certain information, and including, like, for example, all the the OEM manufacturing. If their contracts were clear what's confidential and the other party can't use this information, it might have been an easier case for them to later on take an action against someone who misuses the information. And if the employee resigns, there's all this that you need to do. Immediately disable the accounts, privileges, change passwords, remote access codes, unplug terminated employees' computer systems, remove dial-up modems from your workstations. So you examine their computer before he or she leaves to ensure that employee has access or copied. And then to see whether the employee has access or copied sensitive information in recent months. This actually can be done with the software. So that's why actually a lot of this can be IT enabled. And if you ever need anyone to advise you on this, I can give you a contact person. But there are service providers, IT experts who can advise and give you the right software to assist in security, keeping the security of information in your company. Also, conduct an exit interview with all employees that are leaving, because that's where you will remind your employees of his continuing duty not to disclose trade secrets, confidential information, and any documents that are privy to your company. Right? Here he also says obtain info about his new employer. Do that if possible also in the exit interview. Only reason because you want to ensure that their new employer, when they do whatever they're doing, a new talk or a new presentation, they're not using your information. So you then can keep an eye out whether what's information stolen by your ex-employee. Right? So previously, confidential information, trade secrets, the way that we were protecting them was through NDAs and confidentiality clauses in employment agreements. But that's a deterrent, that's a deterrent. It's not a proactive way of keeping information secure. So now, because with technology, there's a lot of electronic equipment, electronic weapons that you can deploy. So like I said earlier, there's a lot of softwares, you can block access to USB thumb drive if you don't need access. So you need to be pretty much awake in your business and assess, do an audit on what information you have, what is confidential, who has access to this information, who needs access to the information. All right, so that brings us to the end of this webinar, at least the presentation part. We can then move on to the question and answer. But before I end, there's 3 things that we would like you to go home today with, or if you're already at home and watching this, to digest. It is to identify your trade secret and confidential information, prepare the appropriate clauses in the relevant agreement, create a sense of secrecy around the information, and implement and monitor strict policies on the usage of the information. It is your business, so it is your proprietary rights. So make sure you're taking care of your proprietary rights in the right way possible. Right, so I'm going to pass on the session to Ivana, and we can then take on any questions. So please do not be shy and ask as many questions as you can, so that it's a learning session for you too. All right, Ivana, back to you.
Thank you. Thanks, Gita. So
Welcome.
I off your screen. Maybe you can turn on your webcam. Yeah, we have a question.
Okay, hold on, I'm getting the webcam.
So how is everyone online while waiting for Gita to turn on her webcam? A bit higher, lower, yeah. So good.
Okay.
How is everyone? Good. So I just call your name. If you are still awake, can you type A? Then we know.
If you're still awake,
Huh?
I hope I
No, I
didn't
mean
put
some.
anyone to sleep.
Huh? Well, oh no, still around. So not still awake. Sorry. Sorry. Sorry.
It's okay.
No, it's interesting because you say
I'm
like
hoping you're
five or
awake.
seven cases. Five or no five seven cases. Seven cases, and you share tips.
Yeah, it's quite maybe a bit too much.
Yeah.
I might have
Piak,
overloaded
piak.
everyone with information.
No. Piak. I said wrongly. It's around, still around. Okay, so Siuli, oh, a lot around. Marika, Carola, oh, from Jakarta. Tian A, Ian, then who else? Okay, still around lah, huh? Suzila, hi. Okay, so there's one question, two question. Can you see their question, Gita?
I can't. Where is it?
Cannot. Never mind the chat box on the right side. There's a
Okay. Okay.
around. I am. Thank you for responding.
Is it a question by Angelina?
Angelina and Lam. Can you see her question? Her
Okay,
question
yes,
is
I see Lam's question. Okay, let's go to Lam's question.
Angelina first because she key in the question first, so it's like
Oh, okay. Okay, can. Oh, you highlighted
yeah
it here, right? Okay.
yeah
Company A is a service provider company and have all the NDA and restricted clauses on confidential information in place. In case if a senior employee leaves the company A and subsequently clients start leaving to join that ex-employee's new company, citing that they are more comfortable being serviced by that ex-employee, can action be taken on that ex-employee? No. So that's a very good question, Angelina. But no, if the clients themselves seek to be serviced better by their ex-employee, there's nothing that the ex-employer can do. There's no stealing of information there. So you have not walked away, or the senior employee has not walked away with information belonging to the previous company.
yeah. So
So
does
if
this answer your question? No, Angelina, answer your question. So answer is no. Cannot take action.
yeah, so there's no action you can take if clients themselves approach their new company.
And nothing can be done to prevent this in the future. Then every senior
No,
officer leave, then client leave.
it's a fair world. So it's a fair world. So that's where it benefits us as lay people, that you can go to another service provider if you're not getting the right service from your previous service provider. So the law won't
Oh,
prevent these kind of things.
so in order to mitigate this situation, it's best that the company has better relationship with the client, and you get what I mean? It's like the company and as the senior employee, rather than everything pass to the senior staff and do everything. Then the client, of course, everybody
Yeah,
deal
I
with
think a
the
lot of companies.
senior
I think
employees,
a
then
lot of
don't.
companies.
Come again?
No, it's like you said it so well, Ivana. You said it so well because it's so true. But as the company grows, sometimes it's very difficult. It's a challenge I think all companies face. But yeah, it's spot on. So it's a relationship. Everything is done based on relationship and trust. So if the company then lets the senior employee just have all the trust with the relationship, then it's natural that when the employee leaves, that the client will follow them.
Yeah. So next time when the client say, let's go out for lunch, then you say, I just want to join together. Make sure you maintain the
Yes.
relationship with your client. Okay, so but if let's say this happened immediately after the senior employee leaves, like immediately, it's like maybe the senior before she leaves, she already tell the client that she's leaving. Then the client also ready. You leave, I also leave, like that.
Yeah,
So you can.
it's still fair. So there's
Ah,
nothing unlawful.
so still
She's
back to
not
the relationship.
stealing. See, it's not stealing any information. So it goes back to earlier. Is there any information that you've taken, confidential information that you've taken? No, it's an employee knows you from relationship. They know that you started. Let's say it's a spa. You got a spa. You're working in a spa, and you went and started another spa. And they know that you're a damn good masseuse. So they'll
Oh,
leave. They'll go to, yeah. So it's nothing that you can prevent. Nothing that the
yeah.
ex-employer can prevent.
Oh, okay. Can. So I hope this answer your question, Angelina. If you have further question, just let us know. So next is Lam. Lam have question. Yeah. Okay. Production flow.
Can a production flow or business flow be protected? And as it is only shared to specific employees. Um, you can keep it as confidential information. So the word protected is tricky, because when you say protect, it usually means registrable. Is it registrable? So intellectual property rights that are registrable are patents, industrial designs, trademarks, and what else? Copyright is a voluntary notification, but you don't have to register it. So when you say protected, usually it means doing something proactive to get protection. So you can't protect production flow or business flow, because business concepts can't be protected. That means you can't register them, but you can keep them as confidential information. So in that sense, you can protect it. But with the earlier cases I was talking to you, in earlier cases, we talked about how do you actually keep the information as confidential. The information is confidential, so you treat it as confidential. Now the production flow and the business flow, you must treat it as confidential. You only reveal to very few employees. And state it in their employment contract. State that this production flow and business flow are confidential information to the company. Then when you leave and you reveal it to anyone, and there will be a breach of confidence, and you will take an action against them. So that needs to be identified. So very interesting. Earlier I was saying that with confidential information and trade secrets, when the information is already in the public domain. So let's say, Lam, this question of yours, this employee goes to a new employer and reveals this information, and you can sue that employee on the basis that all those three criteria are met. You treated it as confidential and all that, so you can sue, and you got evidence that they took your information. So you have the right to sue them, and you will get a financial penalty, or you might get an injunction. But if another person from the new employer uses the information and leaves to another company and uses the information, you have no rights to sue them, because there's no contract between you and the other party, and there's no fiduciary duty of good faith, because there's no relationship between you and the other party. So once the information is leaked, it's actually quite dangerous, because then you have difficulty putting a stop to that continuous leakage of the information. Remember one of the cases that I presented, it was about how the judge felt that injunction is not right. It should be a financial penalty, because the information is already out there in the public. So how do you stop the public from using the information? It's just too big a scale. You can't stop the public from using information. You can't be suing everyone under the sun. So back to this, you can protect it in the sense that have the right clauses in the agreement, share with only a few people, and indicate to them that this information should be treated as confidential. So it's kind of like a deterrent more than anything.
Okay, thank you. So, Lam, does this answer your question? If you have further question, do let us know, okay? So next is SP. Can we sue someone who has breached an NDA?
Yes, you can. It's a breach of contract. You can sue anyone if they breach a contract. So all contracts, if there's a breach, you can take them to court.
So the key is
sorry.
The key is to determine how complete, bulletproof is the NDA, correct?
Yeah, the NDA. So can you sue someone who's breached the NDA? So you go to what term have they breached?
Yeah.
It will be assessment of what term have they breached. So let's say it's this confidentiality term. Then it goes to what was defined as confidential. What information that was defined as confidential information. So the NDA has to be quite clear in that sense.
And your firm do help people draft that NDA to be that detailed, right?
Yeah, we review NDAs and we draft NDAs. If it's actually only if there's intellectual property elements there, then we do. We look at agreements if they're related to intellectual property rights.
Good. So Lam said thank you. SP also said thank you. And then Angelina also said thank you. So any further question from the audience? If you have question, you can type. Or if not, then when I mention your name, you let us know whether you have question or not. If you have question, type 1 and continue typing your question. If you have no more question, type 0 and we know that, no more question, you're happy with the session, okay? So Siuli, any question? Type 1 if you have question, type 0 if no question. Diana, any question? Kim, any question? Type 1 if you have question, then we will wait for you to complete your question, and type 0 if you don't have question, okay? Amir, any question? Angelina, any further question? Mint, any question? Wong, Eileen, any question? Then Susila, any question? 1 means you got question, then we wait for you to type lah, because normally this kind of question long one ma. 0 means no question. Catherine, YM Lim, SP, Christy, Ian, Carola said no more already. Marika, Lam, Iwan, Saja, Tian Tian, any question? Okay, 0, 0, 0. But there's one question by Angelina, but she mentioned that out of topic, but can we search whether a logo or trademark has already been registered in Malaysia? There's one more
Yes,
question.
you can. So all countries have a database of trademarks, and all trademarks that have applied, the people, either local or foreigners, have applied for trademark in Malaysia or have registered will be in the database. So you can be searched.
Oh, okay. So can be searched. Thank you. Angelina, any further question? So most of them type 0 except Tian Tian type 1. So
Okay.
maybe we wait for her to finish typing her question. Okay. Your line is a bit blur. Let me talk to. So Angelina said thank you. So thank you, Angelina, for your question. So
Welcome.
Let me see, Diana. Okay. The line like grainy a bit now. The audio, the visual. Yeah, the visual is a bit lagging. A bit lagging.
Okay, I think Tian's got a question. So what is the minimum and maximum terms of NDA after leaving employment? What is the minimum and maximum terms of an NDA after leaving employment? Okay, that's a tricky question. So with employees, normally it's a confidentiality clause in the staff handbook or in the employment agreement. So it depends on the employment agreement. In the moment, it may not even be there, but it's not so much what's the minimum and maximum terms. It's basically the employer needs to state what are confidential information that has to be defined. So the information would be defined, and that's what basically the maximum term is. Because if it's defined there, then you know clearly what is being defined as confidential information. But remember earlier I was saying one of the cases, very important that the information is not lumped with non-confidential information. So if the information that is defined includes information that are not confidential, that's where it's dangerous, because it shouldn't be lumped together. It should be clearly confidential information that's specified. So that should be specified in employment agreements or staff handbooks. I hope that answers your question. Thank you.
Okay, thank you. So back to the how solid is the NDA, right? So
yeah, right.
Siu Li, another question. Not yet employee and not yet employee. Interviewer shows confidential drawing to interviewee. The interviewee might disclose the drawing to other company. Can we do something on that? Wow. Not yet employee.
Sounds like a pitch. Okay, this doesn't sound like an employment relationship. Sounds like a pitch when you're doing advertising proposals and so on. So it's actually information. It is confidential information. It's confidential information revealed with a duty of confidence on the other party, and there has been misuse. So all of those, if it can be proven in court that the information was confidential, it was revealed only on a one-to-one basis, and the other party had a duty of obligation, and there's been misuse. So yes, you can do something about it if you have those three elements clearly proven in court.
Yeah.
So how do you prove that? So most of the time, an agreement proves that. So there, a non-disclosure agreement is relevant. So non-disclosure agreement will prove that you've specified that this information is confidential. By asking the other party to sign the agreement, you're imposing a duty of confidence, an obligation there, by asking the other party to sign the agreement. Then the third one is by asking them, by showing court that they've misused it, then you satisfy all the three elements.
Okay,
I hope I answered your question, Who raised the question again?
Siu Li.
Absolutely. I hope that answers your question, Siri.
Okay, so before the interview, you signed the NDA lah.
Yes, before the interview. Okay, so there's another. Yes. Before whatever sharing of confidential information, sign an NDA.
So okay, that's a good tips. So Siu Li. Okay, got it. So any further question? The Ian said that his laptop running out of juice. Oh, he fit his laptop. So healthy one, the laptop. So, and I have no power source. Thanks for information sharing. I'll call or email you for further question. Thanks. Then goodbye. Okay, so good lah. So this is the almost to the end already, because I think should be no more question, right? But if there's question, can email or call CAS International, call Gita, or call the office. Okay, so with that, I think I'll end the webinar by asking your feedback. Are you happy with the session? If happy, type happy lah. Not happy, type not happy lah. And the information is not confidential. It's for public viewing. So Siu Li, happy or not happy? Diana, happy or not happy? Amir, happy or not happy? Angelina, happy or not happy? Mint, happy or not happy with the session? Wong, happy or not happy? Eileen, happy or not happy? Susila, happy or not happy? Catherine, happy or not happy? YM Lim, happy or not happy? Chris, SP, happy or not happy? Christy, happy or not happy? Hey, Ian, you are still around. Means your laptop still have juice. So happy or not happy? Okay, so Ivy Ken, happy or not happy? Carola, all the way from Jakarta, nice to have you here. Happy or not happy? Marika, happy or not happy? Lam, happy or not happy? Iwan, happy or not happy? Saja, and Tian, happy or not happy? So wow, everybody is happy, and very happy. So we will invite CAS International more to our webinar, and they do a good sharing. So we have some more webinar with you. I think two more.
We do. Yeah, for the year.
Wow, so thank you. Thank you, Gita.
Thanks, Ivana. Thanks, everyone, for sharing your morning with me. Bye.
Thanks, Gita. Bye. Good.